Hello and welcome to another episode of Coping with COVID-19 at the Ottawa Business Journal. I'm Michael Curran. A programming note for the many people tuning in for us today. We will be using our interactive polls and our Q&A function to keep everyone engaged. I just want to set up today's topic a little bit, and it is a very real topic that lots of business owners and managers are dealing with. All of us are trying to be as supportive as possible to our employees and trying to accommodate them. What we're doing is we're hearing lots of questions, questions maybe like these. I prefer to work from home. I can't come to work because I'm self-isolating. I have young children and I need to care for them during the workday. Or maybe even the question of I have an underlying health issue and I'm worried about being in the office. So how we deal with employees is a very complex and multifaceted issue. What we want to do today in our quick 30-minute session is provide you with an employment law context around those questions. And even more specifically, we want to approach this issue from the eyes of business owners and business managers. And to do this, Ottawa Business Journal is partnered with a great local law firm. I'm sure you've heard of them, Emond Harnden. This is a firm that is about 33 years old. It's a boutique law firm, which means that it specializes in labor and employment law. Also a bilingual firm, by the way. So let's bring in our guests right now, the experts that will help us unravel some of these issues. So first off, we're joined by Sébastien Huard, and also Larissa Volinets, Schieven. There's Larissa.
Hi.
And let me just get Peter on screen as well. Hello, Peter. Thanks for joining us, Sébastien. Thanks for joining us, Larissa. And Peter, if you've tuned into past episodes, will be helping with the interactive components of today. So he'll be running our polls and also fielding some of the questions. So Seb, I wanted to talk to you for a second. The last time we had Emond Harnden on one of our episodes, we were talking with your colleague, JD Sharp, about reopening businesses. That was back in June. So that was after kind of the forced shutdown. A lot has happened, between that short period of time. In fact, some of us might have thought that, hey, in a best case scenario, our employees would be back in the office, back at work. That's definitely not the case. And in fact, we've seen this week from a numbers perspective, COVID is posing more of a problem. So why don't you just help us set things up a little bit, Seb, here in terms of what's changed over the past few months, specifically as they pertain to accommodating employees.
Okay, thank you, Michael. And I want to thank the Ottawa Business Journal for inviting us to speak to all employers here in Ottawa. So just let's look back at early spring. So on March 17th, as we all know, the chaos related to the COVID-19 pandemic began with a declaration of emergency under the Ontario's Emergency Management and Civil Protections Act. And by March 23rd, the Ontario government had ordered the mandatory closure of all non-essential workplaces, an order which remained in place until the gradual reopening process began almost 2 months later in mid-May. In the labor and employment law world, one of the single biggest changes we saw as a result of these events was a mass shift to temporary work from home arrangements that many employers had to implement as quickly as possible to continue their operations in some form or another. Today, Ontario is in stage 3 of the framework for reopening our province. This means that nearly all businesses and public spaces have been allowed to reopen as long as they follow the public health advice and workplace safety guidance necessary to keep everyone safe. Practically though, what we have seen with some employers is that some employers have chosen to have some or all of their workforce continue to work remotely for a variety of reasons, including health and safety reasons. This might, for example, not be a difficult decision for an employer whose employees can and have been functioning remotely relatively well since March, particularly with the second wave of COVID-19 that is anticipated this fall and that we've already started to see in Ottawa over the past few weeks. And for those employers that have returned some or all of their workforce to the workplace, obviously it's an entirely different world now. From the implementation of measures like mask wearing and physical distancing to more stringent cleaning procedures, to new record-keeping protocols for contact tracing, to changes to employment standards legislation, this is, at least temporarily, the new normal. And employers now have a whole host of new challenges to consider when it comes to their workforce being physically present in the workplace. In addition, in both cases, that is to say, continued remote work arrangement or return to workplace, many employers are already experiencing an increase in requests for accommodation from their employees, which we will discuss a bit more in just a moment, particularly in light of the current return to work school season. If there is one lesson to be drawn from our experience since the spring, it's that there is too much uncertainty surrounding this pandemic to predict any outcomes. An employer's ability to react and to adapt quickly will be key to properly managing its workforce for as long as COVID-19 remains a going concern. Looking towards the coming months, employers can still be proactive despite this uncertainty. For example, employers can begin to consider what types of scenarios they might face related to continuing pandemic, whether it be another provincial shutdown or individual requests for accommodation from their employees, and to think about how they might address and adapt to such scenarios. And we'll walk you through that today during the course of the presentation with my colleague, Larissa.
Well, that's a great way to kick things off, Seb, a great context. I'm going to give everyone tuning in today a quick overview of what you can expect. We're dealing with 3 specific topics here today, and Sébastien and Larissa will walk them through us. The first topic that we're going to launch into in just a second is is needs versus preferences. The second topic is understanding undue hardship. And the third is specific accommodation requests. At that point, we'll be taking your questions. And just a quick note that we will be running 3 interactive polls. Peter will run those. So at this point, let's launch into our first topic, which is working from home, needs versus preferences.
The fact that an employee expresses a preference, that's not sufficient for purposes of the Ontario Human Rights Code to trigger an obligation to accommodate. Rather, there must be a need for accommodation. So there must be a specific provision under the Ontario Human Rights Code that's engaged, requiring the employer to accommodate. As Larissa indicated, whether it's an issue about disability, whether it's family status, and so on and so forth. So for example, where an employee simply wishes to stay home to monitor their children who are engaging in e-learning, but there is either no requirement for the children to remain at home from a health and safety perspective, or there are safe and reasonable alternate childcare options available to the employee during the children's school day, the duty to accommodate would likely not be triggered. So that's an important consideration, because I think that's been top of mind for a lot of parents here in Ottawa. And where the duty is more likely to be triggered will be situations, for example, where the children or another individual in the employee's household is at increased risk of COVID-19 due to a disability, where the children are unable to attend school or daycare in person, or where the employee must self-isolate due to a possible exposure to COVID-19. So it's important to really understand those 2 categories, which are very different and distinct. And those categories will determine whether you need to accommodate or not. And that's very important for employers to keep that in mind.
Okay, well, that's a good preview of our first topic. Peter, we're going to bring up our first interactive poll at this point. Should be appearing on your screen right now. Do you want to walk us through this poll?
Well, Mike, as you said at the introduction, I think a lot of us had hoped back in the spring that by the time we hit this back to school season, a lot of us would be back in the workplace full time. So we want to just get a bit of a sense of the landscape and what the situation is for employers out in Ottawa. What is this? What is the situation? Are your employees back working in the office? Is there a bit of a hybrid, either working at home or back in the office, or are all your employees still working exclusively from home?
All right. Well, we've had way over 100 votes. In fact, we're zooming up there. So I'll close things off. Last 5 seconds to vote, and then we'll take a look at at this kind of question that kind of sets a bit of a context for what we're talking about here. So, and there we go. There's the results. Peter, what are you seeing?
So it looks like that hybrid option, a bit of a mix of being at the office or at home with the approval of the supervisor, is the leading response. I'm curious if I can put this back to our panelists. What are some of the trends you're seeing when you're having conversations with employers?
Yeah, what I can say is that I think this poll is actually reflective of what we're hearing. Obviously, what I'm saying is not empirical. It's just based on the conversations I'm having with my clients, but it's really a mixed bag in terms of in terms of the arrangements that are in place with employees. We're seeing lots of flexibility on the part of employers, trying to be good employers and trying to facilitate these arrangements where there's added value for the organization. But I must say, for the most part, we are seeing our employers being flexible to the extent that they can, and providing kind of this hybrid option, which is allowing employees to work from home and then bringing employees to work. And so that's really what we're seeing at the moment. And in some cases it works, in other cases it doesn't. It really requires employees to be self-driven and self-motivated, and proper supervision and management of those employees. So.
All right, here comes our second topic, which is understanding undue hardship. Once again, we'll go back to our experts. Take it away.
So on the topic of undue hardship, so when dealing with a request for accommodation, employers must evaluate each request on a case-by-case basis to determine if the duty to accommodate under the code is triggered, and if so, whether reasonable accommodation can be provided without creating undue hardship. And undue hardship is a term which is found in the Ontario Human Rights Code. So you must accommodate, yes, but to what point? And that point is undue hardship. And where the duty to accommodate is triggered, the employer is entitled to information sufficient to allow it to assess what type of accommodation would be reasonable in the circumstances. So that's the procedural aspect of the accommodation process, the inquiry process, which is required of all employers to determine what the accommodation, the needs for accommodation. So what type of information will assist in this process will depend on the employee's specific circumstances. For example, for requests based on a disability, the employer will be entitled to medical information about the employee's limitations, their restrictions, the prognosis. So how long will it take before the employee is able to return to work, whether on a full-time basis, part-time basis, or some other position within the organization. The employer is not usually entitled to a diagnosis. And for requests based on family status, the employer will be entitled to information about the scope of the employee's caregiving responsibilities. So what are the needs from a caregiving perspective, and what does the employee need to do to provide this caregiving, the caregiving responsibilities to their children. So following the receipt and review of this information, the employer is entitled to propose accommodation options. So the employer has to provide reasonable accommodation based on the information that is being provided. So the options that will be proposed must be reasonable in the circumstances and must meet the employee's needs. Not the employee's preferences, going back to one of the themes we talked about, but the employee's needs. So objective information. And remote work arrangements, even if they are the employee's preference, may not be the only option available to employers who must accommodate an employee for reasons related to COVID-19. And depending on the information reviewed by the employer, other options might include, for example, a flexible work schedule, modified or reduced hours of work or duties, or the implementation of a PPE and other administrative and physical controls in the workplace to ensure the health and safety of the worker. For instance, a worker who fears that their health and safety is at issue if they come to the workplace. And however, in some cases, for example, a possible or confirmed exposure to COVID-19, we note that a remote work arrangement may be the only safe option in the circumstances in light of current applicable public health guidelines. This requires always balancing human rights obligations, health and safety obligation under the Occupational Health and Safety Act to take all reasonable precautions in the circumstances to protect workers. And these are broad obligations and are outside the scope of today's discussion, but we wanted to note it for purposes of today's presentation. And if an employee is offered reasonable accommodation and declines it, the employer's duty to accommodate is fulfilled and comes to an end. It is important to note that where the duty to accommodate is triggered, the employer is only required to provide reasonable accommodation up to what is called the point of undue hardship. And the employer's assessment of whether providing reasonable accommodation in any given case would create undue hardship must consider three things. So the cost, outside sources of funding, and health and safety requirements, which is probably the last factor being the most important one in the current context. And with COVID-19, the consideration of health and safety requirements also extends to the current applicable public health guidelines. And so proving undue hardship is a high threshold. The employer's assessment of undue hardship must be based on real, direct, and objective evidence, not circumstantial evidence. And arguments about inconvenient, slippery slope in terms of concerns about getting a slew of similar requests and employee morale generally will not meet this high bar. It's important to seek legal advice and explore all possibilities before deciding that an accommodation would cause undue hardship. And the type of job that the employee has will have a real bearing on whether they can be accommodated at all, or at least without creating undue hardship for the employer. For example, it may be essentially impossible to accommodate a dental hygienist or a nurse who is not able to come into the workplace or to see patients due to a disability that puts them at greater risk of COVID-19. Whereas it may be much easier to do so for an office worker who is not public facing, who can work effectively remotely without causing the employer to incur significant additional expense. Even within a single job category, an employer's ability to accommodate may vary depending on the employer's specific job duties. In the case of office workers, for example, a researcher who conducts research independently may be able to work effectively remotely, whereas a receptionist, an administrative assistant who usually works closely with another person or the public may not be able to do so as easily without significant additional expense or difficulty. So I'm going to turn it over to Larissa now.
Yeah, so I hope my sound is better. I did
Yeah, it's good.
Okay,
yeah, we'll
did a
just keep
microphone
that.
change.
Yeah, that's good. That's perfect, Larissa. Thank you.
Okay. So just picking up on the idea of undue hardship, one of the really important things to sort of keep in mind when considering accommodation is you get to undue hardship after you've considered a variety of measures. So it's not a question where the employee says, I would like accommodation X, and you say, oh, that's undue hardship. It's actually an ongoing discussion where we say, these are some of the options, and the undue hardship comes in where no accommodation is possible. So there's always this sort of dialogue and various sort of options and ideas that need to be explored together. One of the things that we're seeing specifically now in terms of remote work is that in the past, employers were a bit hesitant to allow remote work for a variety of reasons, perhaps. And maybe they were able to make arguments that it was undue hardship. But what we've seen now is the sheer number of employers who put employees working remotely, in many cases quite productively and effectively. It may make that more difficult to argue that it would be undue hardship to keep people working remotely when there are legitimate accommodation needs that would require that. So, where employees have been able to remain productive, arguments about the cost probably wouldn't go too far. From a health and safety perspective, there may be jobs, as Sébastien mentioned, where it's not possible, but those who are already working from home, we sort of have to start with this idea that it has been possible. And if there is a legitimate code-based need to continue, then exploring that. And so, just because the undue hardship for working from home argument may be a bit weaker, it still means that the employee has to prove that they have a need for that. So just because they like it is not enough to legally require the employer to keep them home.
Yeah, those are some real practical points there. Peter, we're going to do our second poll now. I'm launching it. You should see it on screen. Do you want to walk us through this?
So this is a follow-up just to some of the points that Larissa and Sébastien were just making. Obviously, employers want to keep their teams engaged and happy, but they also need to balance that against running a business and treating their entire teams fairly. So we want to ask employers, what are your biggest concerns when it comes to accommodating staff?
Yeah, it digs into the issue that they were just speaking to there. So we'll give you a couple more seconds to vote. And Peter, maybe just summarize the results here in a second, and we'll move right on to our third topic. And once again, thank you everyone for participating. The votes are coming in fast and furious. So here's the 5-second mark. 3, 2, 1. And there you go, Peter. There's the results for you.
Okay, so it's pretty evenly split, but definitely the reduced productivity and output is topping the concerns among employers.
Okay. All right, let's move on to our third and final topic. Just a second, I'll get this set up, and here we go. It's specific accommodation requests and various scenarios. Yeah, go ahead, Larissa.
So jumping right into the first one there, self-isolation after potential exposure to COVID-19. So what we may see in coming months is, employees, especially those who might have children returning to school or to daycare, we may see situations where on very short notice, they're going to not be able to come into work for a period of time because either they or someone with whom they live might have been exposed to COVID-19 and they're required to self-isolate. So, when we're looking at these kind of issues, especially if the employee themselves is not ill, they might be requesting accommodation on the basis of family status or association with a person protected by a program. So if someone with whom they live has a disability. So, treating this like any other accommodation request, gathering the information that we need to figure out what either the medical or the family care needs are, and looking at whether it's possible to put a work from home arrangement in place. So certainly if someone's required by public health to self-isolate, we can't make them come into work, but is there a way to keep them productively working from home during that period? And just note that where an employee is not able to come into work because they have to self-isolate and they're not able to work remotely for whatever reason, they may be entitled to protected leave under the Employment Standards Act, including the infectious disease emergency leave. So that one covers situations, for example, where an employee is providing care for a family member or is required to self-isolate.
Okay. Seb, anything to say on this before we, Peter, maybe we'll go, I'm just noticing the time is almost 12:25. We might go directly to Q&A. But Seb, any final words on accommodation requests?
Perhaps just on the issue of e-learning, if time permitting, I'm happy to talk about that.
Please do. Yes, please do.
Yeah, so I can tell you that lots of our clients are receiving requests for accommodation, from working parents whose children will be engaging in e-learning for the coming school year. So that's going to be top of mind for lots of parents. And you can expect that employers will receive a lot of these requests in the coming months if entire classrooms or schools are ultimately required to transition to e-learning in the coming months, and as we saw during the spring. So in terms of the information an employer may wish to obtain to determine what type of accommodation can be offered, if any, to affected employees, this will likely include details of the employee's anticipated caregiving responsibilities. So for younger or special needs children, for example, caregiving responsibilities might be particularly extensive. Meal preparation, medication preparation, supervision, tutoring, etc. Whereas for older and more independent children, this is less likely to be the case. That will impact on whether an employee can work at all, work remotely, or work on a modified schedule. So those are all the questions that employers need to be asking through this process, which we've talked about being the duty to accommodate. So that's the inquiry process where you're asking questions to ascertain whether there's a need for accommodation in the circumstances. So, and then once in receipt of this information, the employer will have to determine whether or not the employer can be accommodated in light of the nature and extent of the caregiving responsibilities. So those are some of the considerations that employers will need to grapple with in the coming months. So I'll just stop it there for now. So
yeah, and Peter, I'm noticing, wow, we have a lot of questions coming in. So maybe we'll see if that third point comes up in our Q&A. But Peter, what are some of our audience members asking?
So the first question, and one that I found particularly interesting, comes from an individual who is at a workplace where the employees have returned to work. And what they're reporting is that some of these employees are not following the basics, the basic safety rules. They're not practicing physical distancing. They're having in-person meetings without basic PPE. So the question really becomes, what are an employer's responsibilities for ensuring that these basic health and safety rules are being followed?
Yeah, so an employer has is the master of its workplace. So they have an obligation to protect the workplace. They have obligations under the Ontario Human Rights Code and also the Occupational Health and Safety Act, and also they're required to follow public health guidelines. So that's number one. Number two, because the employer has the responsibility vis-a-vis its employees, it has the employee to manage those employees, and if employees are not following the employer's direction, procedures, policies, then a friendly reminder, just like being a parent to your children, and at some point it becomes disciplinary in nature, and ultimately it can lead to termination if there's repeated insubordination on the part of employees who are not following suit. And I can tell you in the current context with COVID-19 being such a significant public health issue, if we were faced with an issue where an employee consistently refused to follow direction and there was like discipline on file, I don't think courts would be very sympathetic with an employee of that nature because of as we all know, the consequential impact of employees not following such important public health measures and that an employer is trying to put in place to protect its employees and ensure that they're able to continue operating safely and for profit as well, right? So.
Our next question, this is an interesting one, follows up on the accommodation for childcare scenario. If accommodation does involve reduced hours of work, can an employer reduce the pay of that employee if they're clocking fewer hours? And are there other options available to an employer in that scenario?
Yeah, so where, my sound is okay. Where an employer, okay. So where an employee requires an accommodation, as you say, that may result in reduced hours, an employer is not obligated to pay an employee for work that they're not performing. So if because of childcare needs, an employee's got to go down to part-time hours, they can be paid accordingly with their part-time hours. And again, that's part of the dialogue. So exploring, could they maybe work remotely part-time and in the office part-time, like figuring out ways to sort of accommodate that employee, ensuring, of course, that they're being productive, right? If the childcare needs are such that even if they were at home, they wouldn't be able to be doing work, then yes, the employees are entitled to be paid for the work that's being done.
Here we've got a tremendous amount of questions. In fact, for all of you that are joining us, we might go into extra time a little bit. I don't think I've ever seen this many specific questions on an issue. So let's go at least 5 more minutes to try to help our viewers as much as possible here.
So one actually that several people posed variations of this question, and it's on the first topic that we covered, the needs versus preferences. If I'm afraid of catching COVID-19 and I feel that there's a chance that I could catch COVID-19 by returning to work, is that a need or a preference?
So the answer to that is if the employer has put into place the required health and safety measures to ensure the safety of employees. The fact that an employee is fearful of catching COVID-19 or being infected by COVID-19 is not sufficient in this circumstance. So and if the employee believes that the workplace is unsafe, they have a right to do what's called a work refusal. And whether through a health and safety rep or the Joint Health and Safety Committee, depending on the size of the organization, that will be investigated. If the employee maintains their work refusal, it'll go to the Ministry of Labor, and inspector is going to make a determination whether the workplace is safe or not. But the fact that the employee is fearful is not sufficient in the circumstance.
Another interesting question, and we sort of touched on this theme a little bit about treating employees equally. If, as a general rule, employees are given the option of working in the office or working from home, but a supervisor has concerns about the productivity of a particular employee, can a supervisor ask that that employee work in the office so that they can be supervised to ensure that the productivity is of a sufficient level?
So just on that note, I mean, it's the only risk that an employer runs is one of a discrimination claim that we're treating employees differently. But that's a real and live concern for a lot of employers, right? So if the employer is able to articulate why they are allowing some employees to work remotely and requiring an employee to work at the office, if they're able to articulate that with objectively. There's, I don't want to say there's a guarantee because we can't provide guarantees, but generally that should be sufficient in the circumstance. But I think it's key to articulate, look, we need you to be in the office. We've had issues in terms of your productivity in the past and in terms of your ability to deliver on time, and you require more coaching. Prove to us that you're able to meet those deadlines and be self-driven. Then we'll consider a remote from work arrangement at some point. But I don't think it's a hard no, but it's a maybe. So.
Or you've been able to stick handle every question I've thrown to you. I'm reading these and I'm like, boy, these are tough questions. So
Yep.
here's another one that I think is a pretty tough question, and it deals with COVID-19 testing. In the
Yep.
news, we've seen so many stories about these long lineups, how difficult it is at the moment to get a test. If an employee is sort of in that gray zone saying like, oh, I've got some symptoms that might be COVID related, it might have nothing to do with COVID, but it's so challenging at the moment to get a test, especially with the changing rules. What are an employer's responsibilities to accommodate an employee who has not actually been tested for COVID?
So in terms of allowing the employee to get the test, is that?
Well, more
Yeah.
work from home and
Right.
stay out of the workplace.
Right. So, so number one, an employee is unable to work because they have to get the test, and we all know there's long lineups, and lots of people have experienced that. Then the employer is not necessarily required to pay for that, but some employers will allow employees to tap into their sick leave bank, depending on the language in their employment agreements or the collective agreement that's applicable in the circumstance. But that's generally what would happen, is that they'll grant the employee some sort of a sick leave date, but it really depends on the language in the collective agreement, because technically, if the employee is just saying I'm not sick, but I just want to double check if I've got COVID-19, it's not necessarily sick leave in the circumstance. But I know a lot of employers, a lot of our clients have been fairly flexible on that front. Certainly if it's repeated and there starts to be this pattern, that may be, employers may reassess that, but certainly allowing employees to get tested. Generally, employers will allow employees to tap into their sick leave if they've got paid sick leave, otherwise granting them an unpaid day to get the appropriate test. And the employer has an interest, right, in ensuring their employees are safe and are well and are not going to be infected other employees in the workplace. So
can I just ask a quick follow-up question to that? Can an employer require an employee to get a COVID test? And then the flip side of that, is an employer entitled to know the results of that test?
So the answer to that is no. The employer can't require employees to get tested, but if they believe that employee is exhibiting symptoms which could jeopardize the health and safety of other employees in the workplace, the employer could say, look, I've got concerns. I want you to go to your doctor and have your doctor confirm that you're fit to work because of some of the symptoms that you're exhibiting. And until such time as you provide me with that certification, you're not coming to work. And if an employee wants to challenge that, they can do so. The advice that we've been giving is protect the workplace, protect the workplace, protect the workplace, and protect other employees. That's the number one.
Thanks, Peter, for all those questions. I think we're going to call time. I think this 35 minutes has demonstrated how complex this issue is. And we always know that when we're dealing with employment law issues, that we're trying to provide that broad context and probably just scrape the surface, because there are so many individual considerations. So the key point here, I'm sure my two colleagues from Emond Harnden would agree, is get some professional legal advice. And if you want some great advice as demonstrated in today's show, you should call Emond Harnden and Sébastien and Larissa. So thank you so much, Sébastien and Larissa. You did a great job. We put you on the hot seat there. There's still lots of questions. I can't believe there's minimum a couple dozen questions have come on. But if you do have some questions, continue firing them at us. COVID-19@obj.ca, I think, is the email address. Did I get that right, Peter? You can check on it in a second. But I think that's right. You can send us a link. So that's all the time we have for today. I want to thank again Emond Harnden for bringing these great experts to us. These are, as I indicated, very real topics that you're dealing with on a day in, day out basis, and make sure to have your legal footing when thinking through some of these issues. So thanks again for joining us. We'll be sharing some more information on today's session on obj.ca and our YouTube channel. So if you're looking to on a recap or replay of this, you can look to those channels, but just head to obj.ca. That's all the time we have. So for Peter Cavesi, for Larissa Volinets Schieven, and Sébastien Huard, signing off now. Thanks for joining us. Bye-bye.
Thank you.
Having us.
Thank you.